What do you call it when someone claims emergency power in a situation where there is no emergency? And more importantly, what do you call it when a sitting president keeps acting like the law is optional? This is not a normal hearing, not a routine legal dispute, not another political headline scrolling past your screen. This is a direct collision between executive power and the rule of law, and at the center of it is Donald Trump testing just how far that power can stretch before something breaks. In the span of less than 24 hours, the Trump administration asserted wartime authority to justify deportations, despite the simple, undeniable fact that the United States is not at war. A federal judge stepped in and ruled it unlawful. That should have been the end of it. But it wasn't. Instead, reports emerged that Trump officials didn't just disagree with the ruling, they may have deliberately ignored it. And then came the escalation. Donald Trump publicly attacked the very judge overseeing the case and demanded impeachment, not because of misconduct, but because the ruling didn't go his way. Pause on that. A president invokes powers tied to war where no war exists, loses in court, and responds not with compliance, but with retaliation. That's not a disagreement, that's a pattern. And the silence matters just as much as the statements. There was no detailed legal rebuttal explaining why the judge was wrong. No structured defense of the wartime claim, just pressure, deflection, and escalation. So the real question isn't whether a line was crossed. It's how many warnings were ignored before that line disappeared entirely. Because this didn't stop at one ruling, and it didn't stay confined to one courtroom. While the clash over so-called wartime powers was unfolding, another legal front was already moving, faster than usual, sharper than usual, and far more dangerous for Donald Trump. Lawsuits were filed over presidential records, not as an abstract concern about history, but as an urgent attempt to stop something very specific, the potential destruction of evidence. Let's be precise here. The plaintiffs, led by historians, aren't speculating. They are pointing to a documented pattern, handling of classified documents, prior investigations, statements that suggest control over records as if they were personal property, and now, in real time, a legal argument from Trump's own side claiming he can delete presidential records at will. That claim runs straight into established law. The Presidential Records Act doesn't leave room for interpretation on ownership, and the precedent from Nixon versus GSA in 1977 didn't blur the line. It drew it in permanent ink. Presidential records belong to the public, not the president. So when Trump's legal team argues he has authority to erase records, they're not just making a bold claim, they're stepping directly into conflict with settled Supreme Court precedent. And here's where the timeline becomes evidence. April 7th, lawsuit filed. April 9th, emergency injunction hearing scheduled. 2 days. In federal court, that speed is not routine, it's a signal that judges believe something irreversible could happen if they wait. Evidence could disappear, records could be wiped, history could be rewritten, not by interpretation, but by deletion. Now stack that against Trump's response. Instead of arguing the facts, his team calls the process a judicial coup, not illegal, not unconstitutional, a coup. That word choice isn't random. It reframes accountability as attack. It turns legal oversight into political persecution. But the question the court is asking is far simpler and far more dangerous. If the records are harmless, why is there a race against time to protect them? Because once you accept that timeline, once you accept that urgency, you are no longer dealing with a theoretical legal debate. You are looking at a live preservation fight happening in real time, with the clock running against the court. And this is where the case shifts into prosecutorial territory. The request in front of the judges is not vague, not symbolic, not political theater. It is specific, surgical, and backed by statute. The plaintiffs are asking for an emergency injunction to immediately halt any deletion of presidential records, emails, internal memos, digital files, anything created during the administration that legally belongs to the American public. No gray area there. They are also asking for something even more aggressive, protection of digital systems themselves, because in 2026, evidence doesn't sit in filing cabinets. It disappears with a keystroke. Entire communication trails can be erased in seconds, and once they're gone, they're not missing. They're unrecoverable. And then comes the part that turns this from serious into extraordinary. Judicial control, direct or indirect, over White House servers. Think about what that means. Not a subpoena after the fact, not a document request. Actual oversight designed to prevent deletion before it happens. That is not routine judicial behavior. That is what courts do when they believe evidence is at imminent risk. Now layer the legal foundation underneath it. The Presidential Records Act is clear. Records created in office are public property. Nixon versus GSA confirmed that principle at the highest level, unanimously. And yet, Trump's Office of Legal Counsel memo argues the opposite, suggesting the president can treat those records as personal assets. That's not just a disagreement. That's a direct contradiction of binding precedent. So the court is now staring at two competing realities. On one side, established law, Supreme Court precedent, statutory obligations. On the other, a claim of unilateral authority that has already been rejected once before in American history. And Trump's defense is not to reconcile that conflict. It's to avoid it. He doesn't explain how his position aligns with Nixon versus GSA. He doesn't dismantle the statutory language. Instead, he reframes the entire proceeding as illegitimate, calls it a judicial coup, files emergency motions to stop the hearing itself, tries to remove the judge. That's not a legal argument, that's procedural resistance. And here's the contradiction that matters. If the records are lawful, preserving them causes no harm. If the records are insignificant, freezing them changes nothing. If the records are clean, transparency is protection. So why fight the preservation order this hard? Why risk contempt of court to avoid a simple command? Do not delete anything. Because preservation is exposure. And exposure is the one thing this entire strategy cannot survive. Now take a step back and widen the frame. This is no longer about a single deportation policy or a single records lawsuit. This is about a president asserting power beyond its legal boundary, being told no, and then escalating, not by refining the argument, but by attacking the mechanism that enforces the law. That's the pattern. Claim power, lose in court, defy or undermine the ruling, discredit the judge, delay the process. Repeat. And every time that cycle completes, the cost isn't just legal, it's institutional. Because if a court order can be ignored, if evidence can be erased, if oversight can be reframed as an attack, then the system isn't being tested anymore. It's being rewritten in real time. And this is where the story stops being about one man and becomes about everyone watching him. Because the victims in this case are not abstract. They are not political opponents. They are the public, the owners of those records, the citizens who are supposed to have access to the truth, the people whose trust in the system depends on one simple guarantee, that evidence cannot be erased when it becomes inconvenient. Picture it clearly. Not as a headline, not as a debate, but as a scene. Servers humming in a secured room, emails, call logs, internal discussions about Iran, Venezuela, internal responses tied to investigations, all sitting there, intact, verifiable, accountable. And outside that room, a court moving at unusual speed, not out of aggression, but out of fear that if it waits, that entire record could vanish. That's not politics, that's preservation versus deletion. And when Donald Trump frames that intervention as a judicial coup, he's not just criticizing a ruling, he's asking the public to believe that stopping the destruction of evidence is somehow more dangerous than the destruction itself. That inversion is the real risk. Because if that logic holds, then any enforcement of law becomes attack, any limit becomes overreach, and any attempt to hold power accountable becomes illegitimate by definition. So strip away the rhetoric and ask the question that actually matters. If a president can decide which records survive and which disappear, what part of the truth is left for the public to judge? And if courts hesitate in that moment, if they blink, then what remains of the rule of law isn't tested. It's replaced. If this breakdown made the issue clearer, hit like, drop your perspective in the comments, share this with someone who still thinks this is just politics, and subscribe, because the next development won't wait, and neither should your understanding of it.